and as and when they want to ask any questions, yes, definitely they are most welcome. And I'm seeing a good number of participants, almost about 50, 55 people are there. Okay, so
Sir, yes, sir, you can start. I have muted all the participants.
Okay. So some coordination can be done, like, someone raises their hand that we want to ask some question. At the time, I think they can be permitted to unmute their audio. Okay. So I want our idea and our expectation is that there has to be some good participation. And I believe this topic is also very relevant in today's context because a lot of things are hovering around resolution plans where the assets are attached by authorities, statutory authorities like PMLA or Binami Act or black money. So these kinds of things are now coming in the way of a quick resolution plan. Okay. So thank you, Anjali. We would like to proceed with the discussion. Okay. We have made a brief presentation on this topic, but I would like to immediately add that my role today is only as a moderator. So after an introduction on the topic and the kind of relevance today for our discussions and the IBC process, thereafter we would like to invite all the participants to share their views. Maybe we would like to follow some kind of an order of whoever is asking, whoever is raising their hand or putting their comment on the chat box that you would like to share something. We will request the individual participants to share your views on this topic. I hope this is okay with all the participants, sir. And I am Rajendran, insolvency professional, practicing company secretary. And we also have our team here present. I would like to quickly introduce Mr. Nageshwaran onto my right. He is an insolvency professional, ex-banker, and he is also qualified insolvency practitioner in US and UK. And we have Mr. Nandakumaran, who is a retired DGM company secretary from Indian Overseas Bank, and he is also aspiring to become an insolvency professional. We have our legal team present here. We have Mr. Raghu, Ilamati, Nisha, and Madhumita. So they have helped me in putting together some brief presentation, and they are also available for any clarifications to the extent we could share our little knowledge which we could gather in the past few years. In every case we have handled after 2019, we can say we have specifically requested for kind of immunity from past liabilities, past actions under 32A, but we are not successful in a few cases. We're not being able to get it primarily because the offenses are stated to be under public law. Then you might be aware, all of you practicing professionals, NCLT is not encouraging, NCLT is not coming forward to say that I'll give you a clean chit. NCLT also follows a similar kind of hands-off approach. You please go to the respective forum. This is not the forum.
Yes, sir, some background voice is coming.
Exactly, sir. Exactly. I've been trying to send a message. There is some maintenance work going on the upper floor. Since morning, we have been telling them that we stop it. Anyway, I'm again sending a message to them. Okay, sir. Sorry for the inconvenience. Just 1 second, sir, please. okay, ladies and gentlemen, we left a message to them that at least for about 1 hour, don't disturb us. So hopefully the message will reach.
No problem, sir. Carry on. Carry on.
Okay, no problem. Sir, we'll come to the topic of Section 32A related developments recently. And the very purpose of this 6th November 2025 IBBI discussion paper is to get some kind of documentation from the prospective resolution applicants to say that they are not hit by the any relationship with the past promoters of the company. Basically, when we are talking about 32A, 29A also comes and joins the party, and the persons who are bidding for a resolution plan for a company, they have to establish that they are not having any kind of relationship with the defaulting promoters. That is the idea behind this discussion paper. So far, there were no kind of any specified standard format for seeking the benefit of Section 32A. So one may ask, what happened? Why after 7 years of introducing 32A? 32A is not in the IBC code yesterday or day before yesterday. It has been there since 2019. And if I remember right, 32A came by way of an ordinance first. And thereafter, the Act was promulgated in the Parliament to bring it a sanctity. But the effectiveness, the force on which this IBC Section 32A came into effect, in the Act, it was given retrospective effect from the date of ordinance. And I hope many of the participants would be able to recollect in which context 32A came. So it was the kind of a situation when SR Steel was on the climax, on the cusp of getting a resolution plan approval. So somewhere in November 2019, the resolution plan of SR Steel given by ArcelorMittal got approved. But strangely, even after the approval of resolution plan by NCLT, after a lot of battles, someone in our team was highlighting to me that even prior to this 32A, 29A came into the picture. And 29A also had some kind of connectivity with SR Steel case. Why so? Ruiyas are they were the promoters of SR Steel, and they were very particular to rescue the company and have it in their control, despite a lot of pressures and insolvency related regulations. So they submitted a bid through another company where SR was also involved as a promoter. So immediately the government wanted to arrest hue and cry. How come a promoter who is a defaulter, who is tainted, how can he come through the back door to gain control of the company? So that time, Section 29A was necessitated, and it was introduced again by way of an ordinance. So first 29A came, and thereafter 2 years later, Section 32A came. So only after this ordinance of 32A came into effect, ArcelorMittal brought the money, and the money involved at the time was somewhere around 39 or 40,000 crores. So we can imagine the backdrop of 32A. So 32A is not new to IBC. So what is the context in which we are here today to streamline who will be the eligible party to get the benefit of 32A? I request our legal team head Ilamati to just give a brief idea of 32A. We will not take much time, and thereafter we will open the floor for comments or opinions, views on this format. We'll also show quickly the format given by IBBI on which they have invited the comments. So the presentation what we have made on section 32A is on the screen. This is the first slide, right?
Right, sir.
This is the first slide. But we would like to give a quick backdrop as to why there is a need and why IBBI is acting now to suggest a format and take a views of all the members. Yeah.
Sure, sir. Good afternoon, one and all. As Rajendran sir started the session with the intention behind introducing 32A, it was introduced by way of an ordinance initially, and then due to growing doubts and reluctance among prospective resolution applicants, there was an intention to bring in a provision which would give an immunity to the new management taking over the company, so that this will encourage people to invest in stressed assets, so that the intention of IBC to maximize value and to revive the corporate debtor can be fruitful. So one of the main aim is to provide a clean slate for the PRAs and also to protect the value of the resolution plan, to reduce or eliminate unknown liabilities, so to make IBC a workable mechanism for revival. So this was the basic intention behind bringing 32A. So what exactly 32A provides is, it clarifies that the new management will not have any liability when they take over the corporate debtor. So it gives a foolproof immunity to the PRA. And it also clarifies that no action can be taken against the property of a corporate debtor for any offense that was committed prior to commencement of CARP. By this way, it protects both a resolution plan under CARP as well as sale of the company or assets under liquidation process. Also, 32A clarifies that for such an offense which was committed prior to CARP, the erstwhile management, the promoters, officers in default will continue to be liable, and the respective authorities under different statutes can continue their investigation against the erstwhile management. So this is precisely what 32A provides for. So why this kind of immunity is required is so that we can encourage people to invest in stressed assets, to ensure that they are confident in bringing in the money to revive a corporate debtor, to ensure that the IBC's primary objective is fruitful, and to also clarify to the government agencies like Enforcement Directorate, CBIs, or other Benami authorities, to clarify to them that when somebody is taking over a company under IBC, there is already a provision of moratorium which protects the company from all these kinds of investigation. But it also ensures that no such attachment or liabilities entrusted on the corporate debtor, which will potentially discourage the buyers. So the main objective is to ensure that IBC is implementable.
And I would like to add quickly here, sir. This is always, a point we used to highlight. The assets did no wrong. The people only did wrong.
Right.
So why to penalize the assets? The assets have some purpose, like plant and machinery or land or any technology, intellectual property asset. The asset should be put into productive use. And somebody, because of their misdeeds, because of their unscrupulous transactions or any kind of siphoning of funds, if you are going and catching somebody, you catch them, you continue to take them to task, you take them through the legal process, you punish them. But in the process, the assets should not be allowed to deteriorate. Otherwise, the whole purpose of fighting things is becoming a waste. So that was the backdrop. Can I go to the next slide?
Yes.
So we have listed some of the important cases, but I'm not going to go through in detail on these cases. Manish Kumar versus Union of India and Monet Ispat was taken over by Bhushan Steel. So these are all some of the cases where 32A application was confirmed by the court. So the jurisprudence on section 32A has been wider, has been there, for many years. Unfortunately, somewhere down the line when embassy came, embassy properties was one important case law on the 32A protection. I believe it is on a company which was in NCLT Chennai, laterate, something they were doing some. It's a very kind of different kind of a name, mining company. So that company had some problem, and there was Karnataka government state involved in this, and the IBC process during the time, they wanted that renewal of the mining license to be done because the company is under IBC. So the case went to Supreme Court. Supreme Court said that status quo under IBC moratorium is fine. You cannot ask for any new rights to be created under 32A. So thereafter, what happened? Many cases, the court started saying that NCLT, if you are coming across an attachment by Enforcement Directorate under PMLA or Benami legislation or any other FEMA related attachments, they started saying that, sorry, we don't have the jurisdiction, we don't have the power to give you an immunity or a clean slate. That kind of a view started coming up. So public law domain, any attachment made under public law domain, whether it is applicable or not. Can you please switch to next one? So SR Steel, as I mentioned briefly to you, so SR Steel matter also gave birth for 29A and also for the 32A. So the statutory backing of protecting the resolution applicants and also the corporate debtor and also the assets minus the erstwhile promoters. So that was the main thing. Yeah, please go ahead. Recently, this is an interesting, important development which has been highlighted by our team. This has come as recently as 14th October 2025 by NCLAT. NCLAT Principal Bench, New Delhi, Vantage Point Asset Management Private Limited versus Gaurav Mishra. So in this case, NCLAT has gone to say that IBC gets full protection under section 32A when the resolution plan is approved or the liquidation sale is happening. And also, this case highlighted that the successful resolution applicant, there is no need for them to go and seek a remedy under PMLA. There is no need for them to go. Am I right?
Yes, sir. It will automatically cease to operate is what the court held. Correct. So they ensured that a successful resolution applicant will get a complete protection under 32A. They'll be immune from all attachments.
Correct. I request my team member, Mr. Nageshwaran, sir, recently there was one circular by IBBI stating that IBBI, PMLA authorities and Enforcement Directorate and the ministry, probably the ministry played a catalyst role to say that the assets attached by Enforcement Directorate under PMLA regulations, they can restore the assets, they can restitute the assets to the company through the companies under IBC to the insolvency professional, so that it can improve, phenomenally the valuation for the assets. So do you think that this has also got some kind of an importance now? We are talking about 1232A.
Exactly. See, even in this vantage point, asset management, the main difference here and that is they are only issued a provisional attachment, but they are not gone on to confiscation.
Okay.
There are matters where confiscation itself had happened. Now there is a problem for the resolution professional whether he can include that property in the memorandum, the asset memorandum, and include it in the process of inviting EOI from the people, whether this asset can be brought into that. Now, that was always a point. There are certain cases where even we had handled that way, that we used to put that there is a case on this, a particular thing, as attachments are there. There are sometimes the attachment has happened even after during the moratorium of the SARP of the corporate sector, all those things have been happening. But the authorities have been always coming around with the thing that it is under our attachment. So this was always making a problem for the resolution applicant, whether I will be getting the protection or not. Now, whether that type of even advertisement, announcement can be made by RP saying that this is there, and with that only I am going in for this resolution process, was a question that was again and again being discussed. Now, luckily, because of the various factors as Mr. Rajendran explained, government had come to a situation that, okay, if we do not act now, it will become a problem. So what they have now suggested, give an affidavit. The RP will have to give an affidavit saying that knowingly he is including all these things and the details are all being given there, and subject to the normal process of resolution happening, and if 32A, all the whatever legal team put across, all those points have been considered, and whether that resolution applicant is not in any way related to the existing management or not under the cloud of anything else, he or she, they have got the protection under 32A, and thereafter naturally, none of the government authorities, including people who had confiscated the matter, cannot go against the resolution applicant. So, whether to go ahead with the auction or not, many times that was itself going in the court cases for about a year, 2 years to get that permission to put it in the memorandum. So now it has become a situation that the RP himself can put across an affidavit with the permission of the COC, put across the affidavit and take that asset royally into the estate and go ahead with the process of CARP as well as liquidation subsequently, if it is not completed under CARP.
Thank you,
That
sir.
is what it is.
Thank you, Mr. Nageshwaran. So we go on to the IBBI discussion paper. So here you can see on the screen, a prospective resolution applicant must reveal who the real owners are. So they have to submit a kind of a statement of beneficial ownership. So most of us are company secretaries, in our profession here, I believe. But this program may also have other professionals also. So under Companies Act, we call SBO is significant beneficial ownership. But here it is not significant beneficial ownership. So here we are talking about a statement of beneficial ownership. So this gives an idea of what is the ownership chain. What is the ownership chain? How this company, which is bidding for the IBC corporate debtor by way of a resolution plan, what is the kind of ownership for that entity? If it is a company, what is the ownership chain? If it is other than a company like partnership or even a trust or a sole proprietor also. So the percentage, you can see the next, there is also a requirement to give a sworn affidavit by the PRA about the qualification criteria. But the affidavit, if you just look at it, it is simply saying that I am eligible, I am not eligible. I don't know anybody will say I'm not eligible. There is no question of someone saying that. But the point here is that you are saying you are eligible, and you should also list down what are all the things you would like to highlight to the committee of creditors and the RP to examine your statement. Okay, so we'll go to the numbers part of it, the percentage part of it. What is the beneficial ownership rules follow? They are going largely by the RBI's KYC master directions. These master directions have been issued sometime in 2016, sir? 14, 15. And the updation has been done in 2025. 2025 also it has been done. So largely, the threshold, the cap is shown as 10% plus ownership control threshold for companies and partnerships, and 10% and above in the case of beneficiaries in trusts. 15% plus in unincorporated entities. Am I right?
Yes,
Yeah.
sir.
So this is the kind of a threshold it has been given. The goal is to prevent old promoters from returning backdoor through a new entity. So you can also see, the 32A affidavit, the system will definitely help people coming through a surrogate means to bid for the company and take control. I think the last line is not visible on the screen. It also blocks the binomi bidders and proxy bidders. Okay, right. Okay, we'll go to the next slide. Would you like to show the statement of ownership, the Annexure 1, Annexure 2? So Annexure 1 is actually the statement of beneficial ownership, and Annexure 2 is the affidavit. So before we request the participants to share your thought processes and views, I would like to show the draft format on which the comments have been requested by IBBI. So this is a draft statement of beneficial ownership format. The term beneficial owner shall be construed in accordance with the meaning assigned under Part 4 of the Master Direction of RBI, where a company, PRA is the company, prospective resolution applicant. The beneficial owner is a natural person, whether acting alone or together or through one or more juridical persons, has a controlling ownership interest more than 10% or exercises control through other means. So this is the first threshold for a corporate entity, or it is for a corporate entity where the PRA is a partnership firm. The beneficial owner is a natural person with more than 10% ownership or entitlement to capital or profits in exercise of control through other means. Where it is a trust, the beneficial owners include the author, trustees, and beneficiaries with 10 or more persons. And where the prospective resolution applicant is an unincorporated association or body of individuals, the beneficial owner is construed as person with more than 15% ownership or entitlement. So the second part of it, it says that where the PRA owner of controlling interest is an entity, if it is a listed entity or subsidiary of a listed entity, then these kind of requirements are exempted for them, because under LODR of SEBI regulations, they already disclose all these kind of relationships. So if a company is a listed entity, then they need not undergo through this kind of rigmarole of providing all this information. Please go. And there is a very extensive kind of format they have given. So this is the name, legal firm, legal form, country of incorporation, registered office, address, SIN number, authorized signatory, disclosure in case of listed entities and their subsidiaries. Okay, please go. Instructions for filling up, statement of beneficial ownership and ownership structure, all these things drilling down to the ultimate ownership level they are asking, tier wise. Okay, so they are going by each company and going to the nth person, the natural person, till the time ultimate beneficial ownership, ultimate beneficial owner. So please attach an organization chart, ownership diagram showing the entire control chain up to the ultimate beneficial owners, including all intermediate entities and jurisdictions where applicable. This is if you go through a PRA of an unlisted company, and for example it belongs to a big promoter group, this can go up to some 30-40 levels. It is possible with a control over different entities coming through this also. There is a possibility, right? But Raghu, there is one area where you cannot have more than 2 layers of subsidiary companies. That's subsidiaries. But when a PRA is there, the person who is having a control in the PRA may have different stakes in different companies. So the idea for them is to find out who is the ultimate beneficial owner. Yes. So I'm just adding by way of a small practical experience. Mr. Nageshwaran was running a company a few years ago. So he was trying to sell the company. when RBI was involved in the transaction, RBI was asking who is the buyer. So would you like to share something on that, sir?
Yeah, see,
Quickly.
because it was a company where the license was issued by Reserve Bank of India as a foreign exchange company. So RBI was very particular that almost everything was over, agreements have been signed, everything had taken place. Change of ownership, the license, when it was applied, by the time this 15, 16 circulars came, and probably that was the first company under the license issued by RBI was under the discussion. So they wanted us to really give across the detail of the ultimate beneficial owner of the company which was taking over or buying out my company. It took about 6 to 8 months. And I mean, without naming the company details, I'm just sharing. Finally, they were having the other company, the company which was buying me, our company was 73 companies they had. And finally, even to a shocking thing of it, of course, even the person who was buying out finally gave all the details reluctantly with the specific condition that I only should handle it, and I handled it. In 10 days, we had to put a chart, and the chart finally it revealed that 99.99% was owned by one person and 0.01 owned by his son. But when the 73 companies which were the background of this company which was buying our company out, the initial stages nothing could be seen. So at that point of time, it was becoming a very big thing, and understandably, the ultimate beneficial owner is a very important category, particularly when we say 32A protection should be given for a company which is in no way connected with the existing promoter when they are buying it out, and they give them all the clean slate model. And the 29A, when it is given, naturally, it has to be very clearly understood that the ultimate beneficial owner is not the person who is in the present time involved in the management of the company which is delinquent. So that is one of the reasons why I think understand 29A and 32A are going together with the understanding of the beneficial owner has to be very clear, because we are giving a clean slate to them. It should not again become a backdoor entry for somebody.
Absolutely, sir. So let me run through the second limb of the IBBI circular, IBBI discussion paper. Can you please show me the affidavit in the second thing? This is the format of the affidavit, which is again to be submitted by the PRA. So the first part recital is fine, that I am duly authorized to swear this affidavit on behalf of the PRA, that the PRA has submitted a resolution plan. Fine, please go down a little bit. I hereby declare that the prospective resolution applicant is eligible, is not eligible. So you have to strike off to claim the benefit of 32A of the code on the following lines. So you have to give a brief description on what basis, on what premises, you are able to claim that benefit of 32A. I further affirm that none of the persons who will assume management or control of the corporate debtor pursuant to the resolution plan is a person ineligible under clause A or B of section 32A(1) of the code. I understand that this affidavit is being submitted in compliance with regulation 38 or so of the CRP regulations, and any false declaration herein may attract consequences. Now the question is, the person who is giving this affidavit is saying that none of the persons is ineligible. Okay, so the point is the threshold of 10%, whatever they are mentioning. So anything more than 10%, the previous promoters, the previous persons associated with the company, they are being there in this PRA. Will it actually, bar this company from participating in the process, or it will make them ineligible? Is it a question? Probably we would like to ask the participants, number one. Number two, the percentage of the people, the beneficial owner, on what date we should construe. Is it on the date of COC considering or on the date of NCLT considering the approval of the plan? In my view, Raghu, at both the stages it has to be there. When COC considering also, they have to satisfy that this person is an eligible resolution applicant. And in between, if there is any change happening, they are supposed to update the COC and NCLT also.
Yes.
So in this backdrop, I think we have taken about 30 minutes, 35 minutes. So may I now open the floor for the participants to share your views, and anyone would like to offer your thoughts, please raise your hand, sir. Maybe if more than one person comes, we will just regulate it one by one. Thank you. Yes, Mr. Sunil Kumar, you would like to say something? Please go ahead, sir, if you want to share something. Kasi Vishweshwarao, sir.
Hands up,
I'll come back. I'll be framing the certain issues.
Okay, sir. Okay, no problem. Take your time. I would like to add here, highlight perhaps that almost about 100 participants have joined this program. So naturally, we expect a lot of participation, questions.
Subhajit.
Yes, Mr. Subhajit. I think Anjali, would you like to unmute?
May I?
Yes, please, sir. Please go ahead.
Yes, I wanted to thank the IBBI for this for the circular dated 4th November, in which they have clarified how an IP is supposed to interpret or proceed in terms of assets, PMLA, interplay between PMLA and IBC. It's a wonderful, clarity on how to go about things.
Sir, Mr. Subhajit, right?
Yes, I'm Shubhajit Kaur.
Oh, okay. Yeah, we are not able to see you. If there is an option for you to be appearing visible on the screen, that would add more value to the participants. Yes, Mr. Subhajit, where from you are joining, sir? This.
I'm from Kolkata. I'm from Kolkata.
Very good, very good. A lot of things are happening there. Yes, sir.
Yes. Thank you, sir. Thank you.
Yeah, please go ahead, sir. You wanted to say about IBBI bringing out this discussion paper?
Yes, I wanted to convey my thanks to the IBBI for bringing this wonderful clarity. It adds clarity on how an IP is supposed to proceed in terms of whether as the interplay between PMLA and IBC.
Yes, sir. True, sir. True. Medha Kulkarni ma'am, anything you want to say?
No, this is really helpful, I should say, because there was a lot of confusion on this topic.
Yes, ma'am. Probably, this will enable the COC also to take a calculated view, a proper view before putting their votes on multiple resolution plans. If there are multiple resolution plans, this affidavit, this statement of ownership will give a quick comparative picture who are the real persons behind this company. Maybe if I am thinking aloud, sir, as you said in your example, if Reliance Industries is somewhere involved in taking over a company, so the process might finally reveal Mukesh Ambani or somebody is there, or they may even try to circumvent this also. Suppose they are holding 9.9%, they will not come under the radar.
That's
no, sir. Sir, I feel that there is no percentage leverage in the case of a 32A.
Okay.
32A is very clear that there should not be any involvement of a promoter.
Okay.
But where we'll have to get that, for that some kind of a flooring for keeping a floor, this 10% beneficial owner, for declaration purpose, they are taking this one.
So more people will come even if they are holding less than 25%, 20%, 15%,
Yes,
they will
yes,
come up to
yes.
10%. But the point is that even the promoter, past promoters, erstwhile promoters, even if they are there for a token shareholding also, that will completely make them ineligible, right?
The 32A is very clear that
there should not be any association.
Yes, exactly. There is no involvement of a past people. There should not be
Okay.
in the change in management.
So the idea of the IBBI SBO, Statement of Beneficial Ownership, is just to declare who are all the persons having beneficial ownership, but more than, 10% and above, you please declare them.
Yes.
There is no need to go down the list. Less than 10% people, don't mention them. Other than that, you please mention them. So it is a disclosure. So the percentage is only for the purpose of bringing more people into a view, public view. These people are associated with this company.
Yes.
Better be aware whether some Choksi is there or any other Malaya is there or somebody is there. Please take note. I think this is the purpose. So this was not visible earlier in the 32A cases. I remember in many of the resolution plans, there is no such provision that they will say I am eligible for 32A and all, right? So they will say that I am an unconnected person. 29A,
29A affidavit used to be there.
29A used to say that there was no association of the previous management. Yes, sir. Okay, so we can invite some more comments and views, Mr. Sumit.
Sir, shall I take
Please,
it?
Please, sir.
Actually, this affidavit, see, so many things are happening. Regarding transfer of funds and this under what I call this. Sorry. Cross-border transfer of funds and all these things are happening, and so many shell companies are also in existence, and through indirectly some people are controlling the things. Maybe this PRA might be under their control, which I think would not come out with this affidavit. Will it be possible to get that kind of under indirect control of the persons? Maybe by presuming that whoever is having more than 10% share, if we presume that the 10% share might not be they might not be the owners, real owners, but some other people must be controlling it.
Possible,
and how could we get out the information of such beneficiaries?
Sir, I remember saying that, the courts can have only a legal jurisdiction and not a moral jurisdiction. So the courts have to apply as per law what is there, and as per law whether it is complied with or not. So you can still have a kind of, a de facto ownership, which is happening. Bihar was ruled. I don't know about the election results today. What has happened? Any idea?
NDA clean sweep, sir. More than 2/3.
So there were history in Bihar. A chief minister's family was ruling the state. That's possible. So it's a de facto kind of.
Chief Minister was ruling the state from
Chief
jail.
Minister was ruling the state
from jail.
Okay, so we are not
Lalu was ruling.
We are not
digressing there. So coming back to this, you cannot control a person's, way of doing certain things morally. You cannot say that it is immoral. As long as it is legal, as long as it is lawful, probably I think we have to appreciate and then move ahead. So this one step.
So many money laundering cases are there. Enforcement Directorate is unable to trace the movement of those funds and all these things. In such cases, this affidavit we have to bear. It's a procedural kind of formality rather than digging out the correct person who are the controllers of this.
Absolutely, sir. We will listen to some more participants, sir. Maybe Mr. Sumit Gupta, are you there, sir? Would you like to share? Mr. Murthy? Mr. Murthy Eranki, thank you for participation, sir.
Thank you, sir. Thank you.
Pratibha Kandalwal, ma'am, would you like to say something? Srishti Garg, Pankaj Kedia, Vinit Gangwal.
The objective of getting this declaration is, along with this amendment, IBBI is also proposing another amendment where the COC is required to discuss on the 29A eligibility of the PRA.
Correct.
So unless we have more papers about the PRA,
Correct.
what kind of discussion, what kind of a fruitful discussion can be taken up by the COC?
One more thing, sir. Shall I this regarding so the PRA must be having already some kind of bank accounts. The beneficial owner can be ascertained from the bankers because they will comply with all the KYC formalities and they will be having the information. Once they have given the affidavit, I think we can compare with the bankers also.
Sir, if only the bank accounts reveal entire thing, we probably all the banks.
It's only just cross check.
Yes, sir. It's natural.
Updation in the bank accounts might not happen frequently, sir. At the time of opening of the bank account, only the data might be given. But as on a particular date, bank might not be having that information. So it will not be, it will not be a 100% proof or effective one to take the details from the bank.
Absolutely. I find only one thing that today, if you are having a PAN, individuals I'm saying, so the information AIS, what is that? Annual Information System, the Income Tax Act, it pulls all the information and throws that, what all the things you did, where you went, what you paid, how much you paid, did you buy a car, you went abroad, all these things are thrown out in the AIS of income tax, returns and forms. Unfortunately, the people into corporate areas, they are very careful. They are very, very, clever in structuring certain transactions so that the identity of the final owner does not come out. In many cases, it doesn't come out. So here the idea is to pull out the, ultimate beneficial owner. But I still have a view. Suppose I want to maintain only less than 10%. In these kind of circumstances, I may not be visible, right? If I'm holding only for 9.5% in this transaction, whatever IBBI is asking now, ownership. So my identity may not be disclosed also, but I can wield some more power.
But sir, the declaration format also says 10% is right, 10% of
but control,
and it also says any other means, control through any other means, which is not defined. So it's a very elaborate, it's a subjective thing. Correct. I may interpret it in a different way, I may disclose it.
Correct.
You may interpret it in a different way that you may not give details of certain persons.
Correct.
So this 10% thing is for sure anybody can verify the control with 10% or beyond. But the other means is a bit ambiguous thing, which is very subjective amongst different PRAs.
So still, we cannot say, as Mr. Moti was telling, this can never be a foolproof way of identifying the true owner or the ultimate beneficial owner. Though there can be still some more characters involved, playing for others. Surrogate characters could be there. Okay, so this is the backdrop, and any other views from other participants? We expect a lot of questions. Can I name some persons to ask some questions? Mr. Gagan Buyan, Mr. Munish.
See, I will like to ask, is there an agency where you get this ultimate beneficiary details for somebody? Somebody gives this.
I would love to have, I would definitely love to have one, which can immediately give me all this information for a price. Unfortunately, it's very difficult. You remember when 29A came, a lot of agencies came that I will do this for you, I will do that for you.
Yeah. They sold it all, but the results were not
correct.
as required.
Signal X, there was one company called Signal X.
Yes.
One entry they used to charge.
But we can't depend on them also. No? It is independent duty of the
Yeah,
insolvency
true.
profession.
RP again.
Finally.
Sir,
Correct.
sir, an affidavit from the PRA followed by some due diligence by the RP itself would be the only solution here.
Prince only, sir.
Yeah, Mr. Prince Soni, yes, sir.
Sir, very rightly said that the implementation of 29A and the SBO sections is practically a very challenging role for an IP. So maybe like we have simplified by using information utility like NESL for the debt and the related things, why should not we utilize their facilities and services where we can try to warehouse and put the maximum information available on the lines of AIS, which you mentioned. At least we not reach 100%, at least we'll have some common links and connection available there and a reliable database to find out such relationship and existence of some connections. So
Yes, sir.
because problem is there, we need to also look out for a solution which is viable, economical, and implementable.
Good solution, sir. Good suggestion as well. So, Mr. Prince, you are from which place, sir?
Sir, I'm based in Delhi and I'm an IP.
Oh, good, sir. Good. Very good. Very good. I think this is a good solution along with your suggestion as well as Medha Kulkarni ma'am. If there is some kind of an agency which can collect all this information on a confidential basis and share it for specific statutory purposes like an information utility, NESL. It's a good suggestion. We will forward it to the institute, our IPA. Probably it can reach the IBBI also.
Sure, sir. No, sir, the important aspect of this agency is that outcome report or findings of that agency is acceptable in the courts and the tribunals. It should not happen a private agency report, I'll take it there and it's challenged by anyone. Like today, if I get a Form D or any other report from NESCL, it is submitted and then the appellate or the adjudicating authority immediately relies on that. So that credibility of that agency is also equally important.
Okay, good, sir. Good.
Thank you, sir.
Thank you, sir. Thank you, sir. One question I pose to the audience, whether the eligibility of all these, past promoters are not anywhere involved in the process, it has to be ensured lifelong for the company after the approval of the resolution plan, or for how long? Well, all these things a company is passing through and plan is approved, there is no past promoter. But after everything is done, the successful resolution applicant says, no, I need to involve this gentleman, rightly or wrongly, this fellow only knows the ins and outs of this company, so I am bringing him back. Is there any restriction, is there any bar after the plan is implemented?
Does he have to say today?
As long as the lenders are there, there will be some checks, sir. But once the lenders are out or new lenders come in, I don't think there is any check in any of the provisions of the act or the code or the regulations.
That way, Mr. Murthy, I don't know how many of the participants are also bankers or ex-bankers or something. With the changes happening in the present day structures and the people changing so fast in the bank, and also particularly after the account becomes really NPA or stuck account or whatever, it is being shifted to another entity totally. The branch does not have anything to do with that. We went to one of our accounts where we actually have been appointed as liquidator. And just opposite to the company only, the bank which had given the advance is that this account is in the liquidation for the last 7-8 years now. And total detail, 23 or 25 years, the account had been with the same bank. Just opposite only. But today, the branch manager does not know that this account was with him. One. Second, neither the branch manager nor the promoter who is sitting just opposite about 100 feet away, they were not knowing each other.
Blissfully unaware.
No, sir. There is a subtle difference or there, sir. Actually, if you permit me, I'll just take 1 minute. See, here the banker does have the information. Only he has to spend the time, take the files out, dig it out, and come out with it.
Exactly.
There, actually, who is going to take that pain is what is the question of relevance over here. So, I mean, at the cost of reputation, that is getting shadowed because of the time factor and the interest. And then if it is a statutory requirement, then things will fall in place.
The files also, along with that, move away to the other center. So the branch which was.
But still, you have a record. Still, you have a record somewhere.
Not having any file at all.
Sir, what you are saying, I simply say, we don't have to do anything manually. There is something called CIF. For every director, every authorized signatory, there is something called CIF. Maybe in that we can attach one field, any previous insolvencies or any previous defaults, maybe just an attached to it, so that, as you rightly said, if it moves from one bank to another bank, or if it moves from one branch to another branch, that can be as a ready reference. Actually not required to do a lot of manual work, files and other things. Because at the end of the day, sir, it is the minds, those who will create the ways out to do the inappropriate activities and diverting the funds.
That depends on the purity of the data, bank data.
Yeah. Sir, what do you...
No, you can use information utility as well, no? Because everything is there now. So you can fetch details from there and dissimulate wherever required.
But IU mechanism, according to my understanding, Medha ma'am, it has not really matured into a reliable kind of a thing, because you remember that they send a communication to the company to accept a debt. 3 times they send it, 3 times it is responded or something, then they show it as a debt. And okay, IBC also says Section 7 amended, if the IU records are there, you don't have to even think twice. You admit them into IBC, CART. All these things are there, but the kind of expectation in this format of the ownership level and control, ownership to some extent, I think the numbers can speak, but control is a vague kind of an element. So that is where the discretionary aspect.
That too, you will have to include it is not only the direct controls, it is an indirectly. So how this indirectly can be pinpointed into a natural person, that is very difficult.
Yeah, correct. So I think
control may not always be only ownership, na?
Correct.
On paper, there may be somebody as an owner, but you may still continue to control that entity.
Absolutely.
Yes, Mr. Sumit Gupta.
Yeah, sir. Thanks for the opportunity to speak. So, sir, I would like to add one thing with respect to the the ultimate beneficiary. There is a form which is filed on the NCA with certain threshold. Certain companies are required to file with the NCA with 10% and 25% in case of partnership. So I think it can be made mandatory for the PRAs to file that UBO form, so that even there is a reliable data which is available with the NC, and that definitely can come to a certain platform wherein the IP or the COC can have access to that data. I mean, because in today's time you can everyone can have the access to the data of any company by paying a small fees of ₹100 or so. I think that form can be made available in such situations, so that at least a basic information wherein a corporate PRA is there, the UBO information could be made available, and that could be made available without any threshold. So I think there is a mechanism, and if it is made compulsory, and for the PRAs to fill that form before applying and share that details, I think that can be cross-checked with the the government authority.
Okay, Mr. Sumit. So your suggestion is that the Companies Act provides for SBO compliance. The beneficiary Ben forms are there.
That can be made mandatory for in such situations.
Okay. Are you saying that along with the plan, they should also submit the details, right?
Yeah.
Okay. What has been filed in there? Okay. So
to some extent, I mean, the information could be made available. Plus, until that is a non-corporate kind of PRA, then definitely situations.
Okay, okay, sir. Okay, sir. Thank you, Mr. Sumit.
Thank you. Thanks.
If we collect some civil statement of the persons involved in this PRA or some other statement, like as you said, annual information system from the income tax or income tax returns, if they are also attached to the resolution plan, I think it throws some light. Some kind of due diligence on the part of RP, I think we'll be able to identify the true one.
What's
True, sir. Yeah.
I have a small thing to add to what sir has added. So AIS, TIS and kind of things are not updated on a regular basis. Even if if you see the data for 24-25 financial year was updated, was getting updated until the month of August and September. That's why the ITS gets extended. That could be one of kind of situation, but otherwise also normally the data is updated on an annual basis, not even on quarterly basis. So I think for the previous periods or the past period, it could be made available, but definitely it will help out for the past and later. But we cannot fully rely on those data for the latest things. This is what I want.
Okay, sir. Okay, thank you, Mr. Sumit. Thank you. I think some more participants wanting to share their thoughts. Mr. Sunil, are you speaking to us or you're speaking somewhere? Okay. Mr. Madhusudan Reddy. Srishti, ma'am, you want to say something?
Thank you, sir. It was a wonderful session. First of all, I want to say something about Annexure B, that is the draft format of affidavit, which you have presented now, and you have already asked a question regarding this. At which moment the SRA should provide this affidavit? At the time of approval from COC or at the time of approval from NCLT? As per me, this affidavit should be submitted by the SRA at the time of submission of the plan. At the time of the submission of plan, and along with this, he had to state that this affidavit will be valid till the approval of the resolution plan and thereafter also. And if the SRA will fail, it will be the RP can forfeit their money because he will submit the wrong information at the time of submission of plan, or after that it will not change. And second is, in the affidavit there is two clauses, clause number 3 and 4. Can you please present that affidavit on screen, or allow me to?
Yes, we are doing that. Are you saying that this affidavit is scripted in letters of on the stone, that it has to be valid forever, or
valid? You have asked a query that at which moment it shall be at the time of approval of COC or at the time of approval of NCLT. As per me, it will be valid for till the approval. At least it will be valid till the approval of plan or foreseeable future. Because there will be backdoor entry if 32 after the submission of plan, there will be some derivation of 32A. So as per me, it will be valid till the foreseeable future or till the approval of the plan.
Actually, Ms. Srishti Garg, I think in section 29A, there is a provision that a person who will be part of the management, of the successful resolution applicant, or part of the management of the corporate debtor after acquisition,
yes, sir.
Right, shall not be ineligible person, something like that, it will be there. Okay, so the point here is, I am a good boy at the time of COC approval, at the time of NCLT approval, but thereafter, I invite my old friend to come and join my business. Please come, because I have fulfilled all my obligations to the lenders. Everything is clean, all clean slate. So is there any mechanism to check? Are you saying that, Mr. Srishti Garg, are you saying that basing on this affidavit, after 1 year of NCLT approval and implementation, can you go and ask Bhushan Steel that you had, you don't have any relationship with, what is that company? JSW has acquired, right?
Right.
JSW has acquired Bhushan Steel. So JSW should say that I don't have any relationship with Bhushan Steel after 1 year. Is that for lifelong, the Bhushan Steel people are completely debarred from doing anything with JSW? Is it like that?
Sir, we can't do this. Possible ही नहीं है. Possible ही नहीं है. But we can make law like this कि करना ही नहीं है. Like वो तो पता है कोई नहीं कर सकता. But हम एक्चुअली बैकडोर एंट्री को रोकना है तो बोलना ही पड़ेगा कि आपको ये नहीं करना है. वो तो करेंगे ही.
Sir, I am told by some of my friends that
One question, one more question. In clause number 3 and 4 of this affidavit, in clause number 3, it is stated, I hereby declare that the PRA is eligible / is not eligible. Okay, so I have to declare that I am eligible or not eligible to take benefit of section 32A. And in clause number 4, I have again stated, I further affirm that none of the person who will assume management or control of the corporate debtor pursuant to the resolution plan is a person ineligible under section A and B of section 32A1. So 32A1, A and B say about eligibility or non-eligibility. So if 3 is in clause number 3, if I am not eligible, so clause 4 will be strike off, right?
Yes.
Okay.
Correct. But the point which I am taking from you in point number 4, is it saying that I further affirm that none of the persons who will assume management or control of the corporate data pursuant to the resolution plan is a person ineligible under, they are not talking about ineligible under 29A. They are talking about 32A clause A or B of 32A1. So if you go to 32A1 and see the clauses A or B, possible.
Yes, sir.
32A. Clause A is promoter or in the management or control of the corporate debtor as a related party of or a related party of such person. B, a person with regard to whom the relevant investigating authority has, on the basis of material in its possession, reason to believe that he had abetted or conspired for the commission of the offense and has submitted or filed a report or a complaint to the relevant statutory authority or court. So this is the 32A1 clause A and B. So it is only saying that these people listed in A and B should not be there in the
eligible. Not they are not eligible.
They will not be assuming any control. They will not be
control of the corporate debtor.
Please now go to the affidavit. Good. Thank you for pointing it out, Mr. Shri. You are from which place, ma'am?
I am from Delhi. I am Delhi, Gurgaon.
Oh, good. Okay. All things are safe there. We heard some kind of blast and other things happening there. Now it's okay. Yeah? Okay. So here, I further affirm that none of the persons who will assume management or control of the corporate debtor pursuant to the resolution plan is a person ineligible under clause A or B. B, I can assume that no problem. It is an investigation related thing.
Investigation, right?
A is actually the promoter or a related party of the promoter. But how long this affidavit can hold good? They will not assume management. We are saying that they will not assume management or control because they are ineligible, right?
Yes.
So, how long this affidavit is valid?
They are not ineligible, sir. They won't get a 32A.
They won't get, no. Right now, I am giving this affidavit that they will not be there. They will not come nearer to me in management or control. I will not entertain them. My plan is approved, implemented also now. Thereafter, is this affidavit binding upon me? after implementation of the plan.
That monitoring, definitely it is impossible.
It's impossible.
Who will monitor?
But it is also this particular clause. Is it restricting forever? Once for all, that person cannot come nearer to the company, the previous management.
No.
Yes. If the period is not mentioned, that
Yes.
means for all times to come, this eligibility has to be maintained.
I would rather say the other way. I would say the other way. This company, under IBC process should not go to you. So that we have ensured. Having acquired that company under my control, paying that money, it is my property. That is the successful resolution applicant. It is my property. What I do with my property, I have constitutional rights to do.
But I have given a covenants before acquiring that particular property. I have given so many covenants which I need to, abide by.
Okay.
Who will verify this, sir? Like I approve the plan, NCLT is approving the plan today, 14 November 2025. Plan is implemented in another 2 months.
Okay.
January they complete the plan, or 1 year they complete the implementation. Until then, monitoring committee is there to ensure that all these provisions, IBC, this affidavit, everything is taken care of. So 2026 November plan gets implemented fully in all aspects. And in 2027, they're bringing the promoter as a director or advisor or whatever.
The next generation of the promoter also.
Who's going to verify? Because lenders are fully settled.
Father might have been a scoundrel, but son need not be.
Need not be. Exactly. So there is no COC, there is no monitoring committee. Lenders are fully settled. RP goes out of picture.
No,
monitoring committee chairman is also out of the picture. Who's going to ensure that this affidavit is fully abided by the PRA? Nobody is there. Even NCLT is not.
Even if he is violating, what action can we take? It may not be possible for us to take also anything.
Correct, sir. Correct. So
and one more thing is, so then we need to ensure that this will not happen during the implementation period of the resolution plan. Once
Correct.
it is over, the resolution plan is totally executed, then there is no need. I think it has to be.
Sir, I would say there are two possible things. One is where you allow them to bring the promoter after certain period, maybe after implementation or so, or else you make a self-declaratory part that they will not bring the promoter in future. If they have to bring promoter in future for any cause or any reasons, if they want to do so, they need to go back to NCLT for the direction, and whatever amount which was done as a haircut, they have to bring that first, and then they can bring the promoter. That can be a condition precedent.
Article 21 will be violated, Constitution will be challenged.
Otherwise, it's a criminal breach of trust. They've broken the trust, which is or the declaration they've given in the affidavit. It becomes false, and it's a perjury.
And sir, when we are talking about criminal breach of trust, the people, successful resolution applicant and the past promoters, they can do a number of business other than this company. Is anybody preventing them to do any business?
Not be.
So they can do any other
But
business.
ineligibility is only for this company, sir. So
This
we are
company,
only from
absolutely.
this perspective.
Absolutely. And another thing, people say that, if a crime is not proved, the person is let loose, he is let free. Okay, I saw a recent Supreme Court case, some 20 years or something like that, Nithari killing or somebody, a person who used to kill children and eat their body parts, has been relieved by Supreme Court. So even criminals have joined the society as a normal human beings at later point in time. So here it is an economic offense of inability to pay debts for whatever reason, whether the constitution or the system of law is banning them forever to come into the system. The society.
So that is what I'm saying, sir, that we are not banning, or give them an option that they can go back through NCLT route to acquire the same company or to come into the same company, provided they are able to pay off whatever haircut has happened or whatever liability what
No
people
one
have
will come
suffered.
forward. Why they should come and pay penalty on their own? It is like,
By making declaration, if they want to again come back to the company, then they need to make declaration to the NCLT.
It is like, shooting yourself on your foot. So people will not come that through that route to offer to pay, the sacrifice or the haircut and take over the control of the company. Why they should do that? Am I right, sir?
There are so many other methods by which they can enjoy the fruit.
Like
Why they
Srishti
will do
ma'am,
this way?
like Ms. Srishti
Other
said.
methods are already there, but this is just because in the
Sir,
law. It is provided.
Sir, as per me, this clause should be for foreseeable future because the theft is murder is banned, but कोई करता है तो कंप्लेन करा तो हो जाता है तो आपको बैकडोर एंट्री नहीं देना है at any point of time. So it should be for foreseeable future of time till the implementation of plan, till the approval of plan. The EMS monitoring committee, the COC, and other RP will take care check of that. And after that, if anybody come to know about this, they can file any complaint against the person with NCLT or civil court or any other court. So.
Yes.
This clause, this affirmation for a foreseeable future of time, because we cannot say ki the promoter can enter after the approval of plan, because there is lots of haircut, 92%. After 92% haircut, they will take the backdoor entry. This is not feasible.
What is the possible future or foreseeable future you are saying?
Foreseeable future.
It should have possible future. Somebody is taking over the company. So I think.
No, in terms of number of years, please tell me.
To challenge.
Number of years, please tell me, Ms. Srishti. 5 years, 2 years, 3 years.
No limitation on the year. No limitation on the year.
So the law, as it is, that it does not allow the previous promoter to take the asset. But while implementation or monitoring, who will take care of that? Whether they are
monitoring, there is a monitoring mechanism. That time.
Monitoring mechanism only till it is completed.
Yes.
Not beyond that.
Beyond that,
Right? So it shouldn't, like Nagesh.
Yes, sir. Only at the time of submitting the resolution plan, we should ensure that these people will not come back door. So the persons who are submitting the resolution plan, if they are having already some history of doing the business and in the business like Reliance or Tata's or some people, we don't need to, I think, a formal affidavit will be enough. Suppose a person like me who is totally new to business sector or industrial sector, I am submitting a plan. I am submitting a plan means somebody must be backing me. Otherwise, so this kind of resolution applications should be very carefully scrutinized to ensure that there is no backdoor.
Okay, sir. Let's see. Let's hear one more gentleman, Mr. Sai Ramesh. Yes, sir.
See, I just joined late, but I just want to suggest that it's a corporate structure. So whoever is continuing in the management, for example, a managing director or the CFO or the CEO, just like we take tax compliances from the board of directors in every company on a regular basis, under IBC, a declaration can be given by the continuing management, whoever is at the helm of the affairs.
Okay.
Who signs documents for the company. See, after all, the persons there will be some person who will be designated as a CEO or a CFO or a MD or whatever. He should give a continuing declaration, which a PRA gives, which is being suggested by the IBBI now, that a PRA gives a affidavit. PRA is limited time, as we all have been discussing, maybe for 2 years, 3 years till the plan is implemented. After the plan is implemented, say for just like we take in MAMO Caro or Caro report in Auditor's report in Companies Act, there can be a declaration of IBC by the existing management. Whoever is running the company, I am sure those people can be identified. They cannot be just hiding behind any scene.
Sir, for
So
how
that
long?
may be.
This reporting is for how long, sir?
Pardon?
For how
It can
long?
be, it can be continuous. The IBBI can take a call 5 years, 10 years. After all, you are going with declaration. Only the company continuing management is saying they have not entered my company. The defaulters have not entered the company. That can happen.
Sir, I would like to add something what Sir has stated. So I was just about to say something like that. So if you remember, a few minutes ago, I discussed about the UBO, the ultimate beneficial owner form, which is required to be filed by certain companies with third threshold. I think for the companies who which has been taken over by the new applicants and have been running successfully, and Sir has stated so rightly. So to add to that, I think to the band 2 form which is required to be filed exceptionally by certain companies. So that can be made compulsory again, for the companies which has been acquired, by some participant and have been running successfully.
Okay, okay, Mr.
I
Sumit.
think, yes.
Yeah. Thank you, Mr. Sumit. We would like to hear Mr. Ghanshyam Patel.
Yeah, sir, my view is till the time the resolution plan is implemented, those checks and balances can be made. But
Okay.
once the resolution plan is implemented, that's it. Whether I go with the promoter director, previous promoter director, I go with a third party, I go with any party, that is my choice.
Correct,
Okay?
absolutely.
And there should not be any restrictions, neither from the IBBI side or any side, other side, because that's an independent way of doing my business.
In that case,
Okay.
29A should be amended.
Yeah, it might be amended. That's fine. See, all those applications would be applicable till the time the resolution plan is implemented. Once the plan is implemented, then all the conditions are met. It's over. It's a clean sheet.
Sir,
After that, there should not be anything. That is my personal view.
True, sir. True. I think very practical. So, Mr. Sai Ramesh, where is it saying in section 29A that the tainted person, a person who is a defaulter, willful defaulter, all those, NPA account holder, disqualified person, should never ever be associated with this company lifelong? Is there anything like that?
No, it is silent today and it's being misused. Today, all are. Today, if you see many of the our plans which have been implemented, I can, we have no evidence as RPs. We have to, even CBI does not have evidence to show.
True, sir. True.
So what will happen is the same promoter is controlling and he's a bidder in many liquidation.
Correct, sir. Correct. Absolutely, you are right.
It might be true, but it can be the other way around also. If I'm a free entrepreneur, I can see value with the promoters. I can use his experience to increase my business. I can learn from his mistakes. So it did not always be negative. The problem, what I'm hearing from quite a few of my colleagues, and I respect their views, is that everybody is thinking it is negative, it should not be done. The case is it may not always be the case. That's a simple point which I'm trying to make. So that should be allowed in my view.
You have already punished
adding to Mr.
person.
Patel's statement, I'll just say.
You are not punish the promoters.
No, we have
what Mr. Patel is
from the
saying.
company.
But the loss is more for the public.
Okay. Yeah, Mr. Sumit, you were saying something.
Yeah, so I was just adding something to Mr. Patel's statement. So I think the negativity is closed at the moment it is accepted and is successfully, implemented. Definitely, whatever haircut has been taken and accepted by the COC and the NCLT in the final order. So, suppose it's a case where more than 90% haircut is taken. So already the negativity is accepted. Actually, it is closed. So for the 10% thing, if we go on, though I have made the suggestions that that ban to UBN and you can go for it. The monitoring has to be done, but otherwise, what he has said, I agree to him actually.
Okay, sir. Okay, sir. I have one question. This comes to me from Mr. Nageshwaran. The loss suffered by the lender, you mean to say, or the ultimate beneficial owners of the lender is the government,
Public money.
and finally the public.
Yeah,
The UBO concept, if you apply, we are all the UBOs, right? Public sector money.
Correct.
So what he is saying, you have not punished the promoter by accepting a 95% haircut. You are not punished him, you are saying. So my point is, sir, if you are really concerned about that person's wrong, fraudulent activities, you agree that for 95% haircut, allow the company to change hands. But you pursue against that fellow who forced you to, there was no asset. There was no asset. So because of that, you accepted for a 95% haircut. Like Vijay Malaya, go to any extent, let him not be breathing comfortably, sleeping comfortably, you go after him. Right? What prevents you from doing that? In the same way, what Mr. Ghanshyam, yes, sir, you want to say something?
Yeah, I wanted to say something. While, I just want to support what you have been saying, that, while it is true that
I'm just argument purposes.
no, argument, we're coming to it. The 90% haircut and all, what were the banks doing? Were they blind? Were they sleeping all the time? When Vijay Mallya was taking loans, they were all partying together. And now when it went bad, now that you're crying that it's 90% haircut, 80% haircut. Then how many times you have seen bankers in hands with the promoters? So what action are you taking against the bankers as well?
We have
still going.
It's
still going.
So it doesn't खाली एक हाथ से नहीं बचता है, दोनों हाथ से बचती है. अगर प्रमोटर भी गलत है तो लेंडर्स भी हैंड इन ग्लोव थे एक टाइम में. ठीक है, लास्ट में उन्होंने हाथ ऊपर कर दिए. अभी सब प्रमोटर के नाम पे बिल फटेगा, चलेगा. But that is
unless bankers, where is the ecosystem? This ecosystem may not exist. But once the system exists, then you know pretty well what is the judicial system prevails in this country. Is whether a banker is having any right to prosecute the failed promoter or fraudulent promoter directly. We are all going to the judicial system only. It is taking years together to find out whether he is a criminal or not.
Absolutely right. So that is the main root cause of the problem.
It is
And
not
not
only
that we should put blame only on the promoter for the 90% haircut or when something happens. That is the issue.
Another angle, sir, here one more point.
Incentivize the whistleblowers in this country.
Mr. Harshal Shah, I think we will give him an opportunity to speak.
I also have one more point. When you say 95% haircut and after that you should proceed against the defaulter for criminal offenses and all that thing, not allow him to sleep. Whether it is feasible for I already lost my 95%. Now out of 5%, whatever I have recovered, I have to again proceed against further recovery. With that will also remain. It's putting good money for bad money.
Then you don't worry about that person coming and joining hands. See, on 1% you are saying I'm losing money. On the other hand, you are saying that fellow is back again, enjoying the company of the new promoter.
No, sir. My view was that we should have both the options open. Either you continue with you don't continue with the promoters. You can't allow them to have joint hand with the PRS. And you make a regular declaration, as one of the candidates said, you make a regular declaration that you don't allow, you are not dealing with the ex-promoters and ex-management. That is one option. Or alternatively, if they want to continue with or they want to bring the promoters, ex-management, in that situation, they have to go back to the NCLT and seek direction from the NCLT, wherein whatever money has been lost or haircut that has been given, they have to make good those haircut. So that money they have to bring back, only then they will be allowed to deal with the earlier promoters.
Okay. The people, sorry.
If I may add.
Yeah. 1 second.
Sir, I think we should come back to what IBC is for. We are saying that promoters have defaulted, they didn't do the management rightly, they siphoned off the fund, they were involved in offenses. It's all fine. IBC is not going behind any individual. Yes. IBC just wants to revive the company. It doesn't care about the future as well. To be honest, if we go through the provisions throughout, they only see until implementation of the plan. IBC anywhere doesn't focus what happens to the future of the company.
32A talks about prosecution against the erring promoters.
Correct. But it doesn't say it has to be done. It says if there is going to be an investigation or if there is going to be an interrogation.
No, now IBC brought this discussion paper only to prevent the errant promoter come into backdoor.
Sir, but if we also see 29A,
for that only.
In that case.
You are telling that we are talking that it is not for the individual, it is for the revival of the industry.
Definitely, one more reason why I'm saying it is two things. My reason to say that IBC is not focusing on individual, it just focuses on the company is backed up by two things.
Correct.
One is the preamble and objective of IBC. Secondly, the 29A provision, which we all saw right now, it also says that any person who's assuming control of the management during implementation alone will have to see under 29A.
It's a moral hazard, so that's why it is saying that you should not encourage. You should not encourage, you should not allow them. It's a moral hazard,
true,
right?
but 29A also focuses only until implementation. It doesn't say post-implementation.
Correct.
So we cannot necessarily forfeit a person's right to continue business and his profession throughout his life. He definitely has the freedom to start a new company, to incorporate a new company with any XYZ person and do the same business. But at the same time, I think we cannot curtail a person's right throughout his life to never come back to a company. We are in this way, we are kind of curtailing the SRA also. The resolution applicant also, we are trying to cut his wings by saying restrict yourself to your people. Don't go back to the promoter.
So
he might need expert assistance at some time.
Correct, exactly.
So it cannot be a forever thing where people can keep monitoring. It shouldn't be a discouragement for the SRA to say that we can't take additional compliances, additional responsibility to keep reporting to somebody every year or every month. This might be a additional factor to discourage the SRA.
It is like imprisonment for life. A punishment given for an offense. It's an economic offense. You are banishing them. A promoter, you are banishing them forever.
I have an idea. Okay, after you complete.
Okay.
Can we use the RTA system to a certain extent? That this normally RTA is not having the authority, right to information authority thing, is not having the authority to inspect into the private companies or all these corporate entities and things.
ROC they can do.
ROC they can do. But here, what I am saying on that is, the moment any RTA complaint is lodged against a company which has been taken over under the IBBI or this arrangement, liquidation or CARP, whatever it is, that company will be, let us say, not indefinitely, next 15 years from the date of that one, they are subject to RTI.
Subject to?
This
RTA. So if any one person files a complaint that this company, which was taken over by X after 45% of haircut or 50% haircut, will be subject to the RTA scrutiny. So I will make a complaint. If the complainant is able to get a confirmation, then if he has got a right to proceed against.
But one issue will become RTA, if you permit RTA to have jurisdiction on private companies which come under IBC, it will open a big Pandora's box because anybody can ask any question to RTA and the entire company data is
I don't like you, so I'll send a...
Sir, the question under RTA will be only to the extent of who is the management.
So why should I answer, sir? Why should I answer?
That is what because you have taken over the company, and that also let us
what is there in the company I am taken over, not the 95%. You are not giving me the 100%. You are giving me the 5%.
That is why I am giving 5%.
For the 5%. So why should I be burdened more?
Correct. I will not come to this.
I will not come to the platform.
That is true. But what happened? This is a suggestion. If at all, if this 29A and this 32A, all this verification need to be happening, RTA could be one road for next 5 years, probably 10 years. The matters can be under the ITA.
Okay.
RTA scrutiny. Other than that, it cannot.
Sir, I have one more view. Probably, I think in another 5 minutes we can try to complete this session. Under PG to CD, that is personal guarantors to corporate data, as IPs, probably some of you might be associated. So we have seen some cases where the repayment plan is talking about a minuscule, very absolutely a decimal point, repayment plan on the total amount of dues. Okay, no problem. This gentleman guaranteed all the loans, all the payments. Company failed. Resolution plan got approved, all those things went away. For the balance of money, whatever exercise the lenders wanted to go against the personal guarantors, they are going. Now, we have seen a case where a repayment plan has been approved. for a 0.1%, let's say, or 0.5% of the total dues. The total dues would have been a huge colossal sum. And once the plan is approved, repayment plan is approved, this gentleman is declared out of the insolvency. Am I right, sir? He's discharged completely from the process. Can he not have a fresh start? He can have a fresh start.
That is itself a fresh start. Now I am talking about only the corporates and companies which have been under CARP and liquidation, they take over. I am not coming in here with regard to Section 95 individuals, because that itself is provided that they should be given a fresh start. This 95
Sir, exactly.
afterwards, it's a fresh start.
Sir, the promoters whom we are talking about is a person with a flesh and blood. The promoter, right? Ultimate beneficial owner is a natural person. We are talking about UBO, right?
Yes.
So a PG to CD is also a promoter, right?
No,
He's also a promoter.
that internationally is called fresh start. That's a different one. You refer to Trump. Fresh
Trump,
start.
Correct. Trump.
No, that is an individual thing. That's what I'm saying. That the law is independently, differently handling. Individuals, let us leave it off. I'm talking about any corporate.
No, corporate.
Where the ex-promoters, where what we are trying to say, and that is he should not be having the privilege of entering through the back door. Okay, let us make it for, let us say, to get that information or confirm this arrangement under 29C IA and 32A, let us keep it that this type of corporates for 5 years, it will be under the RBI scrutiny.
Okay, we'll have the suggestion. Yes, Mr. Sudarshan, you want to say, sir?
My question is, do we have a similar circular issued by the Government of India to Enforcement Directorate and the ED Court to handle such cases when it comes up from our side? Because we had seen in the past, the ED Court will not pass orders very easily unless there is a communication to them. If they have something on their desk, so that this if such application comes, we need to handle like this or something like that. Do we have anything such communication to us, sir?
No, I think government has not issued as such any.
But as far as
direction.
PMLA,
There is a circular from IBBI, as you rightly pointed out earlier, with regard to PMLA transactions.
Yeah, correct.
That is there.
See, this,
they can restitute the assets.
Yeah, sir, the circular itself has been done in such a way that this undertaking by IPs before the special court under PMLA, meaning whatever maybe the particular section in the income tax department, which is the adjudicating authority, and thereafter the SAFEMA, which is the Bombay court. Only to them this is being given as an undertaking, and this undertaking is supposed to be taken up on that basis when they issue the instructions to the ED, Enforcement Directorate or PMLA authorities or the income tax adjudicating authorities. Naturally, they are asked to keep away from that. That circular itself is stated like that, and the annexure is, if you read, undertaking by IP before special court under PMLA.
Section 8 of PMLA.
Section
Correct,
8.
Sir, this particular circular is addressed to only we people, like registered insolvency professionals, insolvency entities, and agencies. It's not addressed to them.
Sir, this
what is it addressed to?
Sir, this is a circular which has come out of the Gazette notification, which has already been done by the government. On that basis only this has come.
There is a press information.
PIB has given it in the public, and it's a Gazette publication. So that is automatic.
Lot of spade work has been done, sir, between IBBI and Enforcement Directorate and PMLA authority.
Okay.
That's only this has come.
So this background for this is again from the same Bhushan Steel and that JSW case, where prior to this, sometime in November 24 or somewhere, or 23, somewhere that similar affidavit or more or less similar affidavit was given by, was approved and taken by the ED department, and they released the property to JSW.
And I would like to add one more quick point, sir, before we conclude this session. In one particular instance, we have seen an asset of the company which has been attached under Binami legislation, Binami Act. Okay, so the asset has been funded by the banks, but the Benami transaction took place much later, so 10 years later or 15 years later. But last 10 years, the assessment, attachment has been there. Nobody could do anything with the asset. So resulting which the assets have gone completely deteriorated. They have become scrap. Now, please tell me, by this attachment, the assets have just gone for a zero value. What is the benefit ultimately the government is going to get? So in my view, the assets have not done anything wrong. So to release the assets in such cases, 32A comes very handy. Correct. So to strengthen 32A, they want to strengthen the declarations. Who are all the people who are going to be associated with this company? You please declare. So I feel maybe in the coming months, all such attachments, including PMLA, Benami,
Benami
ED,
cannot happen
FEMA,
because they don't have Section 8.8.
Restitution.
Restitution is not there.
No, that is why, sir. That is why I have a.
should protect.
No,
Correct.
but they have not. Actually, the Benami will not be coming under this arrangement. They cannot.
No, this arrangement is fine. That is
not.
the PMLA arrangement is separate. That is why they have not combined the Benami. But Benami also have to come around. They have to make way for IBC. So with that note, I would like to conclude this session, ladies and gentlemen.
Another one thing is that if every state has their own investors protection code, like in Karnataka we have that Karnataka protection of investors deposits. So they will also attach the properties to get it out from them. That is also I think every state may be having that Investors Protection Act. Those also to be addressed subsequently.
Let them file a claim with the IP. Sir, they have to file a claim with the IP. But what you are saying is the Protection Act, right?
Yeah.
The government is protecting.
Talking about the Karnataka's Depositor Protection Act, which really attached the asset. About 2 months back, there was a order.
So protection so far has all the focus throughout India has been on PMLA. So far, there has been a lot of judgments on PMLA. Benami, yes, there are instances which are being challenged in the court. Similarly, I think Sir is trying to make a point. Exactly. So Sir is trying to make a point. The authorities under the investor protection are also trying to attach the assets, which also will have to be covered by this protection.
But I think, sir, to answer your point, Mr. Sudarshan, when there is a state legislation, when there is a central legislation, the state legislation will have to give way. Okay, so when there is a complete code under insolvency and resolution, this is also this objective of the state also to restore the monies to the shareholders or the ultimate depositors. Am I right, sir? IBC also is having the same objective. So I think in my view, Section 238 prevails over all other legislations.
Still
consistent.
That has to be really taken up, but as you rightly say, sir, state acts will have to be really brought about, and there will be some challenges. As of now, at least ED, wherever the ED cases, because bigger cases are under the ED matters only, so at least to that extent, it will be sorted out.
A few cases dealing with Benami legislation are before Supreme Court. So we expect some kind of a solution or some direction from the Supreme Court in about how many months we can say?
Maybe 2 months.
2 months. 2 months, yeah.
We are all positive because the Chief Justice India designate Justice Suryakant has recently said that every judge who has reserved their order should also state when they are releasing the order, pronouncing the order, they should give when they reserved it, when they pronounced it. So it's a kind of a disclosure. For them to be accountable. So judicial delays are today going completely, unnoticed or unrecorded kind of thing. They say, hey,
it is noticed, it is not recorded.
They have screwed the next by bringing it against the Rashtrapati and also the governors. So now it comes back to them. Now, in your court, in your things, you are keeping things for quite long. How because there is no dates, how many days they can keep it is not given.
So thank you very much all the
Sir,
participants.
one last query. In that circular in which RT had to give undertaking, to the special code for PMLA, that attachment of assets, where RP have to declare that 32A is not applicable, will be not applicable. The director and promoter will not take the company. So it will be till the implementation of plan, till the approval of plan, at the RP undertaking will be forcible at which time? So because we are giving the undertaking to the court. So
Ms. Srishti, the very purpose of this undertaking is to exchange this undertaking for the assets which are attached by them. So you give this undertaking, they will give you the asset. So after you get the asset only, a resolution can happen or a liquidation will happen.
You can see para 6, duration of the undertaking on the second page.
Please read, sir.
Obligation under this undertaking shall
The
remain
obligations under this undertaking shall remain effective until the approval of the resolution plan, stroke resolution order, as applicable by the adjudicating authority.
Okay, sir.
And there it is very clearly given, adjudicating authority, not the COC or SCC.
Or any other,
So it is very clearly given, it is on the second page.
So I think good day.
Yes, sir. Thank you. Thank you so much.
We will have better kind of environment where the attachments have happened earlier. So the assets should get released and we will get more, probably if it is in liquidation, we'll be happy to liquidate and get at least some kind of income, from the assignment. Right now, it is all no visibility on liquidation matters when the assets will, get released, when you will be selling it. So thank you very much, sir. Ladies and gentlemen, all the participants, I think it was really interesting. Many of the participants participated. Still, some more would like to ask some questions, I think. But due to some constraints of time, we will conclude this session right now, sir. Thank you.
And you can
Thank you. Thank you.
Throughout the thing, almost the number of participants were closer to 100.
Yeah.
It
Absolutely.
remained as 100.
Okay, sir. Good. Thank you. Anjali, are
Thank
you there?
you.
Thank you, sir. Thank you.
Thank you, sir.
I think Anjali would like to thank you all formally, sir, as an official vote of thanks if she is there. Otherwise, I would like to propose a vote of thanks on behalf of ICSA IAP. Thank you very much for your being part of today's discussions and sharing whatever information you had, we had, and a lot of suggestions also have come in. So thanks a lot for all your participation and time, sir. Thank you very much.
Thank you.
Thank you, sir. Thank you.
Thank you.
Thank you.
Thank you all the participants for your valuable suggestions. Sir, we are requested to please share the compilation of the suggestion, please.
Tamil Nadu Police.
Sure. Anjali.
Thank you.
Sir, if possible, kindly share by tomorrow because last date is on Sunday.
Okay. For discussion, submission of public comments, I think last date is Sunday.
Okay.
Yeah, we will.
Okay. Thank you, Anjali. Thank you.
Thank you.
Thank you. Bye. Bye, sir. Bye.
Sir, it's
Thank
a
you.
good
Thank
session.
you.